Okay, go.
Okay. Hi. I'm here to discuss today some of the most important HR pitfalls that I've seen in my practice over the years, some of the trends, and essentially I'm trying to give you a heads up as to what are some of the more common pitfalls that you can have when dealing with employees, how to avoid them, and how to respond when something does go wrong. Essentially, the point that I'd like for you to walk away with is to know that even if you have a well-run practice or a well-run HR department with good procedures in place, you're still prone to a host of pitfalls that I'm going to try to educate you on so that you can avoid them in your practice, or if you can't avoid them, at least try to mitigate any damage that they can do to the reputation and the day-to-day operation of the practice. As practice managers, you're all increasingly being asked to do more to help medical practices become more efficient, more fiscally responsible, while at the same time reducing risk. I hope that this session is going to help you or anyone involved in your practice with HR decisions to identify potential problem areas, have the tools in place to reduce the risk, and know how to respond to any employee issue. So we'll start off with the first slide, where I'm going to talk to you about hiring. The phrase that we like to use is when we're consulting, you want to hire more than just a warm buy. What we mean by that is we want to hire someone, you want to take your time, you want to be slow to hire, and you want to be quick to fire. That's the old adage, and believe me, over the years, it's only proven to be more and more true. So what are some common mistakes? Well, for whatever reason, the practice will lose a vital employee. You know, it could be someone working front or back of the practice. You have pressure to quickly replace that individual. So what happens when you have that issue? Well, the second that you have to hire someone, you're going to make a hasty hire. Unless you've interviewed a lot of people in the past, kept the resumes and good notes about people you've interviewed in the past that you just couldn't hire for whatever reason back then. Unless you have something like that, a good bank of people that you can turn to or a good referral source from someone else, you really need to take your time, because hasty hires, we've come to learn, are some of the biggest problem areas and headaches. If you ever have a bad feeling about a potential employee, please listen to it. Your gut feeling, that's not something that I can teach you about, but we've come to see over the years that just like sometimes we see a problem client and a doctor will see a problem patient and in hindsight always say, I had a bad feeling. You ever get that kind of bad feeling? I urge you to really take your time when you hire and really vet them thoroughly. Now, the reason you want to vet them thoroughly is because you want to make sure that they're a good fit. So how do you figure out if someone is more than just a warm body? How do you figure out if does this person fit into the culture of your practice? Well, some of the solutions are on the next slide. We're going to talk about one of the first things you need to do is you need to be transparent with your potential employees. That's key, because if you have an employee, they get hired and they think they're being hired to do receptionist work, front of the house type stuff, but then you really need them to do something in the back of the house, to assist the physicians, to assist the nurses or the PAs. That's a big red flag that we see. When there are unclear job expectations, that leads to employees being cantankerous. It leads to them being upset at the end of the year when they don't think they got either a bonus or a raise based on work that they did that, quote unquote, they were never hired to do. If you have an employee walk around saying, hey, they didn't hire me to do this, that's a red flag. You know, you can't have people walk around saying, well, I wasn't hired to do this. People need to know what they're being hired to do, and they also need to know that there needs to be a little bit of leeway, that at times they may be asked to do a little more. How do you find out if someone is going to be a good employee? The way you find that out is by doing thorough research. Yes, everyone's going to have presumably some good recommendation letters. There's CVs that are not going to say, oh, I like to slack off at work, I like to take 2-hour lunches, and some of my best qualities are pretending to be at work when I'm not really there. Yeah, no one is going to ever say that. What you need to do is you need to really research them thoroughly. One way to research them is to see what their online presence is. That's an entire other presentation that I can talk to you for an hour. But what I will tell you is this. One way to vet somebody before you make a risky hire, or before you make a hasty hire, is go on all the most popular online multimedia and social media websites and platforms. That's Twitter, that's Instagram, that's Facebook, whatever the social media du jour is, you should have a presence there. You can't ask somebody for their password. That's something that's actually been the topic of litigation in the past. Can you ask someone for their password? Can you request that they give you a password? Some courts in the past, believe it or not, have allowed employers to ask employees for their password. Now the trend is courts are now starting to come back the other way and say, no, you can't ask a potential employee to give you the password to their Facebook account so you can read their private message. That's not allowed. But what is allowed is for you to access anything that is considered public domain, anything that is not private. If someone doesn't have a private Facebook account, they don't have a private Instagram account, and you see potentially inflammatory videos or photographs or statements, something that would bring bad publicity to your practice, something that would make you think this person just is not going to be a fit at our practice. If you ever get something like that, don't ignore it, okay? Social media can be used to your benefit. If someone is friends with someone who's a potential hire and they get to see on their Facebook some things that you don't get to see in the public profile, you can use that information that you get from your employee. You can't necessarily direct your employee to go snooping through a mutual Facebook friend's profile, but if they happen to say, oh, you're hiring so-and-so, I'm Facebook friends with them. Look what they posted last night. Even if that person's Facebook profile is normally private, because they are friends with somebody else, that person obviously has no duty to keep that private and can share it with an employee. So again, that's something that you can use to your advantage. Now, when should you not use something that you learned from Facebook, let's say, for a hiring or for denying somebody to be hired? Well, number one would be if it's based on any protected class, you know, like race, religion, sexual orientation. If you do something where you take a negative position, where you either don't hire somebody, you fire someone, you discipline somebody for something you found online that's based on a protected class, then you're just asking for trouble, and that is a very costly lawsuit, and also that's very bad for your practice's reputation. So the one thing that you need to understand is if you're going to use social media to vet employees, which I would highly recommend, what you do is you understand that whatever you see, you can never unsee. You can never unsee that. So if you find out that this one, PA that you're going to hire, or this one doctor out of med school that you want to expand your practice with is pregnant, you can't use that in any internal memorandum. You can't note that anywhere, and you can't use that to not hire somebody. So that's my little sidebar there on social media and its impact on the hiring process, because very important that you use it wisely, but again, you can use it to find out some red flags so that you can avoid hiring someone who could be a potential troublemaker, someone who's not going to be a good fit, but at the same time, you can't ever violate their expectation of privacy. If something was private, you can't force them, or you can't elicit other people to basically violate their privacy. If you can do something publicly, or if there's somebody else who's friends with them who volunteers the information, that's fine. But just understand that. Again, you want to avoid making a rash decision. Never ignore red flags, gut feeling, or whatever you want to call it. And again, it's vital that the employee knows exactly what role he or she needs to play. So, going on to the next slide, when you're hiring, one thing that we notice is that aside from social media, we have bad interviews. You're not really doing your homework if you have a bad, lackadaisical interview process. If someone comes in and you ask questions that are inappropriate, oh, are you married? You have kids? How old are you? What's your religion? What do you believe about this or that? Interviews don't need to be robotic. They don't need to be 100% about can you perform every single task that you will be given. You will be given X, Y, and Z tasks. How many times have you performed it in the past? What have your prior employers said about you? What kind of employee reviews do you get, etc. It's not supposed to be robotic. You're going to be spending a lot of time with this person. A lot of times you spend more time in the office than you do at home with your loved ones. So you certainly want to hire someone who obviously shares some commonalities with you. Sharing some commonalities, having someone who's a good fit is important. But someone who can do the job is even more important. You can have the most likable person in the world, but if they can't do the job, then there's no reason for them to be there. You can't merely focus on commonalities that derail an interview. That's one thing that studies have shown is the number one mistake made during the hiring process. Maybe a doctor's hiring another physician or nurse, and in speaking with them, they find out, oh, they went to the same college, or they know some of the same people who belong to the same country club. Speaking about that for more than a minute is completely worthless. It takes up valuable time that you can use to try to learn about the employee. Important time that could be used to learn about how they would actually solve problems at the practice, as opposed to merely, what's their handicap at golf. That's something that you need to avoid, because focusing on commonalities just derails interviews. So what are some of the solutions? How can you have a better interview? So on the next slide, you'll notice that you want to shift to doing something called behavioral interviewing. Behavioral interviewing is a process by which people, it's theorized, tend to repeat their behavior. So a good question to ask would be something that's related to the job, and that's related to either an issue, a problem, or something that you encounter on a frequent basis that would require that employee to give you their thought process as to how they would react. So, for instance, if you are hiring somebody for front of the house, right, or someone who's going to be the receptionist, and you say to that person, okay, well, at your last job as a receptionist for a practice, how did you handle collecting deductibles or copays, I should say? How did you handle handling copays when the patient thought that they really owed no money? Or how did you respond to a patient calling angry because they didn't understand their obligations to pay additional money because of a co-insurance issue, or they just didn't understand how a deductible works. You know, how did you talk a patient down who was angry about having to wait too long? You know, these are things that will tell you, well, if they behaved in such a way in the past, you know, they'll tell you how that should be a good indication of what you can expect in the future. People don't change. People tend to behave the same way to the same stimulus. That's the theory. Behavioral interviewing focuses on figuring out, did that receptionist, you know, answer the phone in a polite manner, explain it, offer to, you know, give the, offer some additional materials or direct them to their insurance company, or did they just get into a yelling match and hang up the phone? You know, it's important to know what and who you're hiring. You need to ask behavioral questions to determine how a candidate will respond in a given situation. Once you find their answer, then it's easy to make your determination whether their approach is actually in line with how you expect that they would act at your practice. You know, is this what you would expect somebody at your practice to do, how you expect them to react? So now we'll move on to what I was touching upon earlier in the next slide, which is hiring and using social media correctly. An employer who's oblivious on the social media presence of employees and potential employees is absolutely, you know, at risk. Healthcare is particularly susceptible to heightened scrutiny, discipline, and fines. You know, protecting health information is the #1 thing that all practices should be concerned with. Right now, the Office of Civil Rights, OCR, is conducting their phase 2 of HIPAA compliance. So they're looking at every practice to make sure that every practice has HIPAA compliant subcontractor agreements. So if you have any subcontractors that your practice deals with, you need to have a subcontractor agreement. If you do not, you'll have my email at the end. Contact me and I can set you up with a HIPAA subcontractor agreement for free. Make sure that you have one with every single one of your subcontractors. I know you might say, well, this guy, he's just a painter. He just comes in and he's going to paint the offices, you know, well, nobody's here, no patients are going to be here. Well, unless every single patient file, you know, is put away, unless there's no sticky notes anywhere, no dry erase boards with any patient name, unless you can guarantee me that there's absolutely no way, no how that he would see anything that would identify a potential patient or patient information, even your painter should have a HIPAA subcontractor agreement. HIPAA compliance is super important. I don't need to tell you that, but I'll tell you this. OCR is on a spree right now of finding practices, both large and small. We just recently, I just recently wrote a stat law Q&A, which is a free publication that we give to practices. If you're not signed up, again, my contact information is at the end of this slide. I'll make sure that you're signed up for these for free. I just wrote an article about a recent OCR fine of a hospital that was, you know, over $2 million. Now, what happened? This hospital had some very lax requirements. They had laptops that they would give to their employees that were not individual laptops. So one laptop could be given to 17 different employees and you wouldn't know. One of the employees lent his laptop to an ICU patient's relative to access for email because it's the only thing that had Wi-Fi in it. Well, unfortunately, that laptop had access to about 10,000 patients. There was, therefore, when that laptop went missing and then, you know, was presumed to be stolen, they had to report it. But because they didn't know whose information was accessed, if anybody, their investigation actually revealed that nobody was actually, nobody had their medical records access. The OCR still said no, but you had such bad habits and you had such bad policies and procedures in place that we are going to fine you over $2 million, and we are still going to make you give notice to every single one of those 10,000 patients because there's a possibility that their information was accessed. So think of it that way. You know, here's a situation where, yes, there were some bad policies, yes, there were some bad procedures, and yes, someone had a mental lapse that led to a computer that could sign on and access medical records. Someone lent that and it got stolen. These are very bad things. But not one patient's information was ever shown to have been accessed. There was no loss really to any patient. But still, just the fact that they had such bad policies, it caused this hospital an incredible amount of embarrassment, because now they have to self-report to 10,000 patients. It's given, now they're going to have to probably pay off a lot of those patients, because there's going to be a lot of lawsuits. They may have to do as other practices have done in the past and pay for a year or two free of LifeLock, just to give the patients peace of mind that their identity is not going to be stolen. And then on top of that, they got to file they have to agree to be monitored by the OCR for 3 years and to pay a fine of over $2 million when not one patient filed with access. That is how important it is to know when you're looking through the social media account of somebody, whether they are posting everything under the sun, what they have for breakfast, their workstation, things like that. If you see them doing that, that is a red flag, huge red flag, because the harm to the reputation can be as devastating as any lawsuit. And the smaller the practice, the more likely that bad reputation can seriously harm your bottom line. Employees, social media posts, not just potential hirees, but then employees' social media posts can affect the practice. There was another famous case out in California where a student doctor at California, Berkeley's medical center, saw that a star athlete from one of the women's teams was rushed in over the weekend. This was years ago, and had alcohol poisoning. So what did that person do? Well, he basically posted on Instagram, and decided to hashtag every single negative thing you could possibly hashtag about somebody, calling that poor girl a drunk, bad decisions, stomach pump, et cetera, et cetera. Obviously, you might be sitting there and thinking, well, obviously I wouldn't do that. Yeah, and you're right, you probably wouldn't do that. That's probably why you're trusted to manage an office. You wouldn't do that. But you have to know that there are a lot of people who do that. There was another famous case of a physician who decided to have a blog about what happened in his emergency room. Well, that's all fine and dandy, except for the fact that someone then realized who he was. He tried to pretend that he was in another state far away. He gave himself a different name. He never posted any pictures. But what happened? One day, he complained about a coworker coming in, showing drug-seeking behavior, asking for a lot of pain pills. But then what happened? This person went on that blog, happened to go on that blog, saw that the facts matched up exactly with her facts, and was able to deduce that this doctor wasn't in Albuquerque. He was here locally, and in fact, it was the doctor that she saw the day before that she works with. Try explaining that to, the Board of Medical Examiners when the doctor has to go and say, oh, well, it's just a blog, or I just decide to, talk about my interactions with patients, but, using aliases to protect the innocent. The Board of Medicine does not understand that. They barely understand what a blog is. So to try to get them to understand why it's okay for anyone at a practice to be sharing any protected health information, whether they think they're scrubbing it or not, whether they think they're being coy about it, or they're only showing it to other private accounts, people that they're only friends with, it's never okay, and the board is going to come down very hard, be it the board of nursing or the board of physical therapy or the board of medicine. You know, they all have a zero tolerance policy for this type of abuse. So, some solutions in the next slide. Again, we talked about this before. Search social media. Is the information publicly available? That's the one thing you need to concern yourself with. If it's publicly available, fair game. You know, they should have been private. If they're private, you can't befriend them just to obtain that information. Again, if someone at your practice happens to be friends, then you can use that information. I'll give you an example. There was an EMT who responded to a call, didn't like the patient. He posted on his Twitter, you know, I hate this patient that we had last night. I wish I could just go to his house and punch him right in the mouth. Obviously, that's something that you want publicized if you know, you're a private EMT company and, you know, this is one of your EMTs, you know, saying that he wants to harm one of your patients there. So what happened? Well, nobody at his company was actually, you know, friends with him on Twitter. Well, no one followed him on Twitter. But one of his followers on Twitter that he followed as well happened to be the daughter of the HR manager at his company. So through his daughter, the HR manager was informed that, hey, by the way, so-and-so is posting this about the people that, you know, he's picking up, you know, in the ambulance. That EMT was fired. He sued, saying it was an invasion of privacy. The court came down and said, no, that information, although not publicly available, is publicly available to everyone that is on your Twitter feed or can be on all of your Facebook posts and friends. Whoever you share that information with, if they in turn share it with one of your coworkers, supervisors, etc., it's fair game. So again, only publicly available information, and you can't force anyone to go in and search, only volunteered information to you. Gather information that's relevant to your job search. Again, you don't need to find out if so-and-so, you know, who they're going out with now. You know, it's not, you're not supposed to use it, you know, like TMZ. This is supposed to be used, you know, for a job purpose. You know, if you see that they're posting a lot of things that give you worry, you know, give you cause of concern, whether they can keep private health information private, for instance, that's absolutely relevant. You know, if they feel like they're oversharing and they share a lot about their work experience or their prior jobs, clearly something to be wary of. If you just say, oh, well, this person's a Trump supporter, I don't like them, or this person's a Hillary supporter, well, I don't like them, that is not relevant to your job search, and that's not something that you should be relying upon. You know, and definitely not something that you should ever put in a memo to the doctor or whoever's in the hiring committee. You want to scrub all internal memorandums or reports of all references to protected class status. A, they're completely irrelevant. B, it's not privileged, these internal memorandums, no matter what you write on them. You can write privileged and confidential. They're not. But if you put anything in there, just understand if there's something inappropriate and that person then sues and they start subpoenaing records and that internal memorandum or report pops up, then you're absolutely looking for trouble. Last thing I will say about social media is you should really have social media policies in place. If you need copies of social media policies, feel free to contact me as well. Those are also free of charge because you're MGMA members. You know, so I'll be more than happy to provide you with a free copy of a sample that you can use to create your own. If you need help creating one that's tailored to you, contact me and I can definitely help you out or point you in the right direction as to who may help you out. So the next slide, we're going to walk away now from the hiring process. We'll talk a little bit about training. So for training, you want to avoid the trial by fire. You know, this is another common mistake that we see a lot that leads to litigation more than anything. So you're hiring a new employee. but you don't have the proper training system in place so that that employee knows exactly what's expected of him or her. Trial by fire is used a lot, and which is a lot, back in my day when I started out in law, basically they said, okay, well, here's the case, do your best with it, try it, go to depositions, do trials, etc. That trial by fire does not work for everybody. Some people thrive in it, some people do not. Some professions are a little more, it's a little more appropriate. Maybe in law it's a little more appropriate because there is no substitution for that experience of actually having to have your own trial and, and be in charge of it and have no one there to assist you. That's something that every trial lawyer needs. So maybe it's good for trial lawyers. Would I do that with an employment lawyer? Would I do that with a transactional lawyer who's never once drafted a contract, but I have them work on the merger of two practices or the sale of a small practice to an ACO? Absolutely not. So trial by fire is not one size fits all, whether it's law, whether it's medicine. There are studies that show that there's a clear benefit to providing employees with proper training and guidance. I know this is very common sense, but a lot of practices just think, okay, well, you're hired for this job. It's self-explanatory. Do what this person here does, or just basically do X, Y, and Z, and you're fine. It's better if you write them out to give them a good expectation of how they're going to be reviewed, of what duties they're supposed to be doing. Because again, going back to what I said earlier, the last thing you want is an employee walking around saying, well, I wasn't hired to do this. You need to have a good training system that goes hand in hand with expectation. So let's go to the next slide. Some solutions to avoiding this trial by fire, the training. Well, you want to provide a clear direction about what's expected in the role. One of the big problems that I've seen lately in discrimination lawsuits especially is a lot of discrimination lawsuits start with a misunderstanding of what the role of that employee is. A lot of times it starts as a manager or someone in a managerial or supervisory position, a supervisor, not getting along with an employee because that employee is not doing what's expected of the employer. I had one case where a practice was sued for discrimination because, the supervisor was a different race than the employee, and the employee claimed that she was being treated unfairly because of racial reasons. When you spoke to the manager, it was clear that, well, it has nothing to do with that. It has to do with the fact that she was hired to be front of the house help, and every time that the phone rang, or any time that there was a patient that needed an intake or to be processed, she was nowhere to be found. So what would happen? He would yell at her, and then the yelling would become a little more stern, and then they had a couple of back and forths where they were bickering with each other, and that is essentially what led to this lawsuit. Out of anger, people say stuff. They'll curse. They'll maybe say something that's a little insensitive, and in a bad context, it can look very bad. So what happens? What happens is you get sued. Once your practice gets sued, you start incurring a lot of fees because essentially you're paying your own attorney and you're paying the plaintiff's attorney, because under New Jersey's employment discrimination laws, the losing party, the employer usually, even if you settle, has to be responsible for the fees of the plaintiff's attorney. So it's something that's it's a very sensitive topic, and you really need to make sure that you avoid getting into that dispute, avoid getting into that acrimonious relationship between a supervisor and employee by first providing clear direction about what is expected in the role. And if they don't meet those expectations, a clear understanding that they will be terminated. New Jersey is an at-will employment state. That means that you can fire somebody, someone can leave their job, and there's nothing you can do about it. You don't need any rationale. So don't think that you need to find a reason. You can just say, this is what's expected, you're not meeting your expectations, you're terminated. And that's it. You don't need to give any further reason. To ensure that an employee knows what's expected, we suggest mapping out things that they can expect to be proficient in the first 30, 60, and 90 days. Depending on how complex the job description, you may not need to go beyond 60. If it's a very complicated position and they're going to be asked to do a lot, maybe you might have to go out to 120 days, maybe 150, It all depends on how much you expect this employee to be doing and how proficient you expect them to be. Tailor the training to each specific job. You can't have a generalized training module. If someone's being trained to be, an NP, it's not going to be the same as a PA, and it's not going to be the same as someone who's going to be an MA who may be drawing blood and then, helping out with some vitals. Training should be tailored to each specific job. And lastly, help new employees settle in. This is something that employees definitely appreciate. And when a recurring theme that we've seen in litigation in the past, employment dispute, is when not only are there no clear expectations, there's no training, but then the employee said, listen, I was drowning in work and no one was helping me, or I was doing X, Y, and Z wrong, but instead of teaching me how to do it the right way, they terminated me. These are things that not being helped out, not being assisted to settle in, that harbors, some ill will, and you definitely want to avoid that. The next slide talks about discipline. And if I'm going to be repetitive about anything today, and there's one thing that you're going to take away about discipline, is the word consistency. Consistency is key, and it is the most important thing when it comes to disciplining employees. If a practice reacts differently when a violation is from a physician or a preferred staff member, you're asking for trouble. That different standards are ripe for discrimination lawsuit. Sometimes you have a practice that has multiple physicians, and each physician may have his or her own staff. Some staff, let's say, work for surgeons. Surgeons bring in more money, so that staff maybe gets a longer lunch hour, or they get to leave a little earlier on in the summer, or they get to, come in a little later, or they don't have to clock in, with the same frequency, or they don't get chewed out when they fail to, note how many copies they made for a job or whatever it was. That is completely impermissible. You cannot do that. You also can't ignore or fail to admonish somebody, even if they're a doctor. If you have social media policy that says, hey, you can't tweet anything with protected health information, you can't, do selfies with the patient unless you have something clearly in writing from the patient saying that you can do so, then you can't do it. If a nurse would be fired or suspended or sent home without a day's pay or whatever for violating one of your policies and procedures, then a physician should have the exact same punishment. I know that sending home a physician or suspending a physician or disciplining a physician is a lot harder and can be seen as really detrimental to the practice at times. But if you don't do it, it again creates this caste system that it makes it ripe for a discrimination lawsuit. You definitely don't want to do that. Everyone should be held to the same standard. I understand that that's not always it's easier said than done, but you really don't have an option, unfortunately. The next thing you definitely need to address with a zero tolerance policy is sexual harassment. When sexual harassment is not addressed properly, it's grounds for an action of hostile work environment against the whole practice. This whole notion of, oh, boys will be boys, or, oh, he was just joking, or, oh, he's just got a funky sense of humor, you know, that does not play well. Not in court, and I've yet to see it win. That's not an argument that you can make. We represented multiple doctors who've come in with, you know, every kind of excuse you can think of. Oh, well, you know, it's a cultural thing. I'm Italian, so I like to hug. I'm a hugger and kisser. Well, I'm sorry, but there is no separate, you know, Italian standard. There's one general standard, and it's you don't touch your employees, you don't touch people, your patients, you know, in an inappropriate, non-consensual manner. We've had a lot of situations where there was inappropriate comments back and forth between staff and physicians. But what happens? Eventually, somebody takes it a step too far, and what ends up happening is you end up having a massive lawsuit, and the excuse of, well, she does it too, or, well, he did it too, or, well, she started it, never works. That never works. We had one plastic surgery practice that had a lawsuit from a employee. The employee was a staff member. That staff was very flirty with each other and with the doctors. They had an instant message system within the office where they would be messaging each other. Sometimes, you know, there would be sexually charged and sexually inappropriate comments. So what happened one day was, oh, and another thing that, for reasons beyond my understanding, some of the staff members who were also patients of the practice would tend to at times flash some of the doctors when they were walking by. Again, for reasons completely unknown to me. And one day, after a series of you know, texts and messages, all happening, by the way, on office computers through the office messaging system, what happened was that you had the doctor change into his workout gear and go out because he was going out for a run during his lunch break. One of the staff members decides to flash him on his way out, which apparently was standard, you know, at that practice. Well, what wasn't standard is what the doctor did next, which was to pull down his pants and flash her back. Again, everything that I've said here is wildly inappropriate from both sides. That environment was completely toxic. The actions of the staff were completely inappropriate, and the action of the doctor was completely inappropriate. But it's the action of the doctor that led to, unfortunately, the practice being sued. And when the practice was sued, the jury really didn't find that the staff member's conduct warranted or welcomed the, I guess, unwanted return flash of the physician. So again, that was a lawsuit that was settled out of court for a lot of money, and you know, it's something that you need to understand, that you can't have that type of environment because it just doesn't work out, and it only leads to somebody eventually going one step too far, and then the entire practice's conduct is called into question, and those are grounds for hostile work environment action. So what's the solution? Well, on the next slide, they're pretty easy. You know, we've discussed them before. You have to be consistent discipline, you know, for violations of practice policies and procedures. You can't have any preferential treatment whatsoever. And if there's an issue of sexual harassment or misconduct, you have a zero tolerance policy on it. You have to do 3 things, and I want you to really pay attention. You need to do these 3 things whenever there's an allegation or an accusation of sexual harassment, hostile work environment, or misconduct. The number 1 thing is you got to treat it with dignity. If you brush it off, if you make excuses, if you question that employee, that is not good. That plays terribly before a jury. That doesn't come across well when you read it in the deposition. You have to treat every complaint with dignity. Whether you believe this employee or not, whether you think someone's making a bigger deal out of something or not, treat it with dignity. Number 2, investigate it. You can't just say, okay, well, thanks for bringing it to my attention. I appreciate it. I'll let you know what happens. Talk to people, take interviews, document your efforts. The 3rd thing you have to do. When you investigate, document everyone you talk to, get statements, get them signed by the person you got the statement from. It's important that you document your efforts, because if it leads to litigation, it'll show, I got this complaint, I investigated it, here's what my findings were, here's what everybody's statements were concerning this, and, you know, when you can show that you treated it with dignity and you had a zero tolerance policy, that's always in your best interest. So moving on to the next slide, performance reviews. Everybody's least favorite thing that they have to do. Performance reviews, you have to do them, and you have to do them right. The common mistakes is performance reviews are not done regularly. Reviews are superficial. You don't really get to the bottom of, you know, what this employee was doing right, what the employee was doing wrong. And every employee receives the same rubber stamp review, noting that he or she is a good employee. If you're not updating and revisiting if you're not updating or revisiting during the year when something noteworthy happens, you're basically leaving on the table potential issues to raise with the employees should something go wrong. There's a reason why rubber stamping reviews noting someone's a good employee is a bad idea. The number 1 reason is based on litigation. If you terminate somebody, and again, you don't need to terminate them for cause. There's an at-will employment here in New Jersey. But if someone says, I was terminated for pretextual reasons, meaning I was terminated for improper reasons, you know, because of my race, because of whatever, then because the first thing they're going to do is going to ask you for all employee reviews. If they see that this person has great employee reviews, the same, 5-star reviews every single year, it's going to make it almost impossible for you to prove that they were a bad employee. You may have 10, 15, 20 anecdotes of things that employee did wrong over the last 5 years. But if they're not noted in the review, if they're not put in the chart and something else, some addenda to the review, and if that person's getting good reviews every time, then, at the end of the day, you're not really doing anything. You're not really doing anything. You're not really reviewing somebody. All you're doing is creating risk for yourself. The second thing that I'd like to talk to you about now is some solutions. Now, feedback should be given on a continual basis. If you're not getting feedback on a continual basis, then that is a big problem. You have to understand that you're also supposed to be honest in your assessment. You can't play favorites. Just like with discipline, you have to be consistent. Again, with your reviews, you have to be consistent in your assessment. If what one employee did, what employee A did is impermissible, employee B does it, it's also impermissible. You can't have a double standard. It's a good idea to supplement the employee file during the year and discuss issues during the review. And the number 1 thing that I want you to take away from this is that, I want all of you to agree with me that you're no longer, if you've ever done this before, you're no longer going to do rubber stamp reviews. Review period should not be, well, let's stuff the cobwebs off these old forms and just, fill them out the same way we filled them out last year. That should never be the case. One of the last things I'm going to talk to you about is job expectations. Again, we already talked about this a little earlier. With job expectations, you want to set a clear goal. In the next slide, you'll see there are common mistakes that practices make. Unclear performance expectations can result in dissatisfied and frustrated employees. That's what you want to avoid. Once you have a frustrated or dissatisfied employee, then you're already behind the 8 ball if there's ever a situation where, if given the benefit of the doubt, it wouldn't result in a complaint. But unfortunately, if you have a dissatisfied and frustrated employee, you're not going to get that benefit of the doubt. You got to have, for lack of a better word, good bedside manner with your own employees. Problems arise when the manager and employees don't have a clear and full understanding of what is expected. When the employer says, I expect this, and the employee thinks, well, I thought your expectations were something else, then you're never going to be seeing the performance eye to eye. Again, going back to what I said a bunch of times before, I'm not paid to do this. It's not my responsibility to do this. Well, that's not necessarily true. If somebody was hired to do a job and the job requires something that sometimes goes beyond the stereotypical or prototypical duties of somebody working in the front of the house, somebody working in a particular position, it's absolutely fine for you to expect more or have additional duties and responsibilities. You just need to know that the employee needs to know what that is so that the manager and employee are seeing things eye to eye. You want to avoid ambiguous ratings, such as exceeds expectations or below expectations, because again, expectations could be completely different for the employee and employer. In the next slide, under solutions, you'll note that the objective should be set as meets expectation level. Did they meet the expectation? Not above or below. Did you meet the expectation? At the beginning of the year or at the end of the previous year, you set what the expectations and goals are for the following year. It's really easy to do if you work in a sales department. Okay, well, I need you to sell, $500,000 of, units. That's easy. It's a little bit more difficult when you're talking about, different staff members. It's exhausting. It's going to take time. It's going to take effort, but you're going to really reap the benefits of it. All objectives should be set at the beginning of the year, or like I said, at the end of the previous year when you're actually reviewing them, talking about what the goals are going to be for the next year, and it should be clearly communicated to the employees. All goals and objectives, of course, should be tailored to the position because, the front of the house employees are not going to have the same duties as back of the house employees, and physicians are not going to have the same requirements as physician assistants. So the last 2 slides here, I'll go through quickly, are some common mistakes and solutions to running the practice like a business. Medical practices have a tendency to be very informal, but you need to sometimes remind the physicians there that it's still a business, and unfortunately you need to remind sometimes the employees of that too. Some practices have insufficient or no practice policies and procedures at all. That's inexcusable. This day and age, every practice should have employee manuals. Every practice should have HR policies, social media policies. There should be policies and procedures for almost everything. You should have clear expectations for what's expected of everyone at the practice. HR practice managers who have taken on HR duties, failing to focus on employee retention, that is one of the things that harms practices the most when you lose a good employee. And then going on to the last slide, solutions. Some experts have suggested considering a policy against hiring family members. The reason for that is because once family walks through the door, they need to understand that the personal relationship ends and the professional relationship begins. There's no favoritism. We talked about that before. There's no double standards. We talked about that before. You know, and when you don't have that, you know, when there's certain employees, whether they're significant others or friends or family members who are getting preferential treatment, that really harbors ill will, bad feelings, hurt feelings, and a lot of times ends up in losing good employees at a minimum, possible lawsuit as a worst case scenario. Rules of conduct should apply equally to everybody. Salaries should be based on market data, you know, fair market value. The number one reason that people leave jobs is because is not necessarily because they're underpaid, but they leave bad management. So that's why if they feel that they're being paid something that's, you know, based on market data, they don't have to be the highest paid 10%, but if they feel like they're being paid in a range that's within the market data and they have a good manager, you're going to have a good retention policy. And then lastly, you want to ensure your employees readily understand all policies, procedures, and expectations. I thank you all for spending you know, your lunch hour with me. If you have any questions, you can always contact me at that email there. If you need any additional documentation, you know, you can always contact me, and I'd be more than happy to help you. I thank you. I thank MGMA, as always, for this opportunity. And if you have any questions, feel free to email me or call me.
Thank you, Guillermo. If anyone has any questions, you can type them in the question box now. But I think you covered everything, so it doesn't look like we have any questions. And New Jersey MGMA would like to thank you for attending, and the presentation will be emailed out to all attendees this afternoon. Thank you.
Thank you.